operation of his car the night of March 16th. Second, is Mickey Winters responsible for the legal cause of any injury to the plaintiff? And third, does Mickey Winters owe damages for any permanent injury that the plaintiff may have sustained? In just a few moments, Honorable Judge DeMasso will instruct us on the law applying to this case. Among the things he will tell us is that we need to find a reasonable balance. Has the plaintiff shown enough weight of evidence to outbalance the evidence in favor of showing that Mickey Winters was negligent, that he caused the injuries, and that he owes damages? Has the plaintiff really shown a greater weight of the evidence when we balance? The plaintiff bears the burden to do so. They have not met that burden. Plaintiff's counsel showed you the law and read it to you. Said that it applies. Any person operating a motor vehicle on the streets or highways shall drive in a careful and prudent manner, having regard to the width, the grade, the curves, traffic, and all other attendant circumstances, so as not to endanger the life, limb, or property of others. Failure to drive in such a manner shall constitute careless driving and a violation of this section. He told you how a driver sped through the intersection. He told you how a driver ran into the side of another car coming from the other direction of an uncontrolled intersection. He told you how that driver never hit his brakes. He told you how that driver had his headlights on but didn't see the other driver coming. He told you that that driver approached an intersection which he thought was uncontrolled and then drove through it. The only problem is he had the wrong driver. That was the plaintiff, not Mickey Winters. You heard from the testimony of the case regarding the negligence involved. How Mickey Winters drove reasonably under the circumstances, 10 miles an hour less than the speed limit in a 30-mile-an-hour zone, and how the plaintiff drove 5 miles an hour less under the same conditions, under the same two-lane road, without any traffic control on it, 5 miles an hour less. Mickey Winters told you he was aware of the circumstances. It was raining. He stopped at every stop sign along the way, 3 others before he approached the intersection where the accident happened. Now, he would have stopped if there had been a stop sign there. It was, but it was bent over 30 degrees, less than 5 feet off the ground, in the dark of a rainy night. A stop sign that couldn't have been seen in the clear light of a bright and sunny day. Mickey Winters didn't pass a stop sign. For all practical purposes, there was no stop sign there. And why wasn't there? Because the city of Miami, responsible for maintaining such traffic control devices, allowed it to be in that condition. If there's a cause of this accident, this unfortunate circumstance, and we must point to someone, we need to look to the city of Miami. Not to Mickey Winters, who was only driving home on an unfamiliar route to avoid traffic, to get home to his family as he does every day, and obey every traffic law he could, and avoid causing an accident. In truth, neither party had the right of way. We're very sympathetic to the plaintiff. No one likes to see a person in pain. No one takes any delight, and no one doubts that the plaintiff feels pain. Mickey Winters, though, should not be paying the plaintiff for the rest of his life for the pains the plaintiff has accrued in the course of his activities in life. Secondly, the cause of the injury. Mickey Winters caused the plaintiff's injuries, such as they may be, such as they are. We've heard the story of the plaintiff being involved in active, you might say violent, aggressive sports that involved impact, collision, wrenching, twisting for 20 years at the varsity level, the competitive level, in wrestling and soccer, as a recreation. Soccer, a game, when you think about it, where the head is used many, many times in the course of the game to hit the ball. How different is the texture, the firmness of a soccer ball versus the cushioned seat back of a car? It's the same. And the impact between the back of the head in an accident involving a car moving 20 miles an hour against the seat back of the driver's seat is much less than the impact of a soccer ball falling 20 feet in the air across a 50-yard field. When you think about it, think of the impact. We're talking about head and neck injury. For 20 years, this type of activity. Plaintiff even complained to his doctor, Dr. Gomez, of neck pains when he went in to see him about an injury he received while playing soccer. Plaintiff himself knows the results of his overly active lifestyle in sports. The plaintiff had a previous accident, much the same way. He claims in this accident that he had a front-end collision, which is really the same as a rear-end collision that he had before, 1993. The momentum he described in both was that he was thrown forward and thrown back. Why is it now that he turns to Mickey Winters to pay him for injuries sustained in an accident that happened, whereas he had the same accident in 1993, never complained of a single injury or pain, other than those he received in his sports activities? He also gave two different stories about what happened in that injury to the back of his head. You heard Dr. Middle say that the plaintiff told him he injured his head when he flew back and hit his head on the seatbelt. Well, the plaintiff himself said, no, he hit his head on the back of the seat. Dr. Grant said he told him he hit his head on the rear windshield of the car, shattered it out. 3 different ways that happened. Now, perhaps Dr. Middle heard him wrong. Perhaps Dr. Middle transcribed his report correctly. Maybe he meant to write down seat back. Just like Dr. Grant meant to write down C3 and C4 instead of C4 and C5. Perhaps Dr. Middle's secretary made a mistake when the secretary put down seat belt instead of seat back. When you consider Dr. Grant's testimony and the significance of a typographical error in his report, you might consider the significance for Dr. Middle as well. And third, does the Mickey Winters owe the plaintiff for permanent damages? Dr. Grant has told us that the plaintiff is not suffering from permanent injuries. 20 years of experience, an expert countless times in these types of matters, reviewed the record, examined the patient, gave his professional opinion, only to be called out because of the fees that he charged. Dr. Middle The plaintiff's doctor is owed $7,400 for 5 visits in an MRI from Dr. Middle. Why doesn't the plaintiff question the fees he has to pay his doctor when he's all too eager to question the fees paid to Dr. Grant? You'll be asked in a few minutes to give your verdict on this verdict that the plaintiff's counsel also gave. One, was there negligence on the part of the defendant, Mickey Winters? No. Was there negligence on the part of the plaintiff, Jason Smith? Yes, there certainly was. Was there negligence on the part of the city of Miami, which was a legal cause of the damages? Yes, there was. Do you find the plaintiff, Jason Smith, sustained a permanent injury within a reasonable degree of medical probability as a result of the accident? The evidence in the case cannot allow you to check yes. You must say no. And the damages, if you're to divide any damages to Jason Smith at all, 50% should go to the city, against the city of Miami, and 50% against the plaintiff himself. Members of the jury, do justice in this case. Do not make it payday for the plaintiff, who is seeking to take an unfortunate event and an accident and make a payday out of it. Don't hold Mickey Winters responsible for the pains accumulated in a lifetime by the plaintiff of his own free will. Return a verdict, the only just verdict, to the defendant, Mickey Winters. Thank you.
Plaintiff, you were 12 minutes and 30 seconds on your closing, so let's do a 30-second rebuttal.
May I proceed?
You may.
Unfortunate events. The only thing unfortunate in this case, it's unfortunate that the defendant ran the stop sign. It's now unfortunate that the plaintiff is permanently injured, and it's unfortunate that he will have to live with pain, prescription drugs, and therapy for the rest of his life. Members of the jury, we've seen that the evidence has shown us that the defendant was negligent. His negligence was the legal cause of Mr. Smith's injury, and Mr. Smith has suffered permanent injury. We ask that you return the only verdict that is just, the only verdict that is supported by the facts, and the only verdict that is required by the law. That's a verdict for Jason Smith, because the defendant did not drive responsibly. Thank you.